Okay. So, hi, everybody. I'm speaking to you from the conference room at our office, and we are located at 20 East 6th Street in Suite 206 in Waynesboro. And you can reach us at 717-655-2676. And I really appreciate you all getting on the virtual seminar with me. We had a great turnout last month when we did the powers of attorneys, and so we wanted to continue that on and do a session on last will and testament and estate administration. We covered so much in that first session with powers of attorneys that we wanted to devote an entire session to estate administration. So thank you so much for joining us. And I'm going to go ahead and share my screen because I do have a PowerPoint to help us kind of all follow along. So hang on just one second. Okay, so again, this just has our contact information, our address, and where you can reach us at 717-655-2676. And I am recording the seminar, like I said, and you can find our YouTube channel. I have the link right here, so you can jump on there. After a session, what we do is we post it on there. You're welcome to post comments, questions, anything like that. Additionally, I have everybody muted, so that's why you can't hear any background noise. So what I'm going to have you do is any questions that you have, I'm going to ask you to enter it into the chat box. And I'd be happy to answer questions as we go along so that I can make sure that I'm addressing any questions or concerns that you have. So with that, I'm going to get started. So the title of today is Kicking the Bucket Gracefully. And I have two visuals here. One, I feel like maybe he's kicking it gracefully, and in the second one, probably not. And when Amy and I, our marketing coordinator, were trying to come up with a creative way to discuss this, one of the things we talked about was kicking the bucket. And so many people stress about what happens at end of life and how to make sure that it's a more seamless transition to the next generation. So we really wanted to focus on that. So we're going to talk about how to kick the bucket gracefully. And along with that, we're going to talk about some tricks to beat death and taxes. Now, I recognize you can't beat death. However, we can make it a little bit easier when you're passing your assets to the next generation. So Benjamin Franklin said that the only certain things in life are death and taxes. So knowing that, how can we better prepare ourselves? So today, what we're going to cover is probate. We're going to cover how to make your last wishes are followed in your documents, and even just as they're administering your estate, how do we make sure that happens? Talking about discussing protecting your family, and then what you can do now to save money later. So the first thing I wanted to cover is what exactly is probate. There's a lot of misconception about probate and what that means. So I wanted to talk a little bit about that. So the word probate is just the process where when someone passes away, their will is established judicially as the duly executed last will and testament of the decedent. If the decedent died without a will, then the heirs of the decedent are determined at the time. And so that's what we call intestacy law. That would be if somebody doesn't have a will, how do we make sure their assets get to that next generation? After the will is admitted to probate, the court then issues letters of testamentary or letters of administration. The letters of administration would be if there is no will. And so right now, what's interesting, and I wanted to speak a little bit about what the probate process is right now with everything that's happened with COVID. And Tammy and I, she's our estate administration paralegal here in the office. We've had the opportunity to do several virtual probates. So normally when you do a probate, you have to take a copy of your driver's license with you, and you have to have the original will and then a petition to probate. And you have to take all of those documents, you go up to the courthouse, and what happens is the gals at the courthouse administer an oath that the personal representative or the executor takes. We sign some things. I sign something as the attorney, and the personal representative or the executor signs something. So that's what the normal process looks like. With everything that's happening with COVID, the courthouses have allowed us to do virtual. So we've done virtual probate in Franklin County, and we've also done virtual probate from Bedford County. And so both of those have been really seamless. It only takes about 20 minutes. We do like a Zoom call, and the person has to sign everything watching on the camera, and then we're able to get them appointed. So I'm not sure what that's going to mean long term. It's been really helpful because one of the probates that we had, the person was not actually in Pennsylvania. They were actually in another state, and we were still able to probate. So it makes it really helpful. So I'm going to remain hopeful that this virtual probate may stick around, and it will allow us to be able to do it much easier for those people that you're appointing under the will. And again, the executor is the person you name in your will who's in charge of getting the assets where they need to go. And the administrator is the person who's appointed by the court if you don't have a will. So if there's no will, then it's intestate law. That's how your estate is distributed. And intestate law just means that there's a statute in Pennsylvania that dictates how your estate is distributed. And it may not be the way that you actually want it to be distributed. And so I gave an example here. So if we have John and Jane Doe who are married and they have one child, and Jane dies and she didn't have a will at the time of her death, what happens? So we're talking about intestacy. So what does the Pennsylvania law say? So in this case, John is going to get $30,000, the first $30,000, and then one half of the estate. And then their child is going to get the other half of the estate. So in Pennsylvania, it doesn't assume that you would want everything to go to your spouse. It actually has up to a certain amount going to the spouse, and then it's divided between the spouse and the child. Another example would be if John and Jane Doe are married and Jane was married previously and had one child with her first husband, and then she dies and she didn't have a will, and what happens there? And there, John gets half of the estate and the child gets the other half. So unlike in the first example where John got the first $30,000 before it's divided, in this case, it's just going to be a straight division between John and the child. And I bring this up, and I actually wanted to have an example because I think so often when I'm meeting with clients, they just assume, well, if I don't have a will, it automatically is going to go to my spouse. And Pennsylvania law doesn't say that. It depends the value of your estate. Because again, if it's under $30,000, that would be one thing. But most people are going to have an estate over that amount. And so there's going to be a certain amount that does bypass the spouse and actually go directly to the child or the children that are living at that time. So where do you have to go to probate? Probate is in the county that the decedent last had their principal resident. This is important because Tammy and I had fun. I think it was this time last year. We had somebody who grew up in Blue Ridge Summit and had a bank account at M&T Bank, but had actually been living over in England. And we're going to talk about the value that can be in bank accounts when you don't have to probate. But in this case, there was enough funds in the bank account that even though the individual didn't reside here in Pennsylvania anymore, we still had to probate her estate in order to be able to transfer those funds to her husband who was still living. And in that case, what we did is even though she didn't live in Pennsylvania at the time of her death, we looked at where she had last resided in Pennsylvania, and that was in Franklin County. And so we probated in Franklin County. So how does the probate process work? So our office would prepare the petition for probate or the grant of letters. We would prepare notices, and the notices are going to go to the beneficiaries under the will. So there are certain people who have to receive notice saying that this individual has passed away. And we call them the 5.6 notices. And then there's a certification of notice. And those are things that, again, we have to make sure that we're giving to the beneficiaries. And then we also, because we're opening up a probate estate, it's also our job to then inform the courthouse up there what's happening and make sure that they also have a copy of those notices. There's an advertisement that has to occur. So it actually has to be in a paper of general circulation and then a legal journal. So if you passed away here in Franklin County, it would be in the Franklin County Legal Journal. And then most likely the Record Herald, the Public Opinion, one of those papers. And usually how we decide that is if there are multiple papers, usually we recommend that you go with the one that's the most cost efficient to advertise. The reason why the advertising is important is because when you advertise, that starts the statute of limitations for creditors to be able to come forward. So if, let's just say, my dad passes away today and we advertise tomorrow, then 1 year from tomorrow's date, creditors would be barred from coming forward. So again, it's 1 year from the date of the first complete advertisement. That's when creditors could no longer come forward. So we also then like to send a notice to the Department of Public Welfare or DHS, Department of Human Services. And that would be if the decedent was over 55, then it says that the guidance says that a notice should be given to DHS or Department of Human Services. It was previously Department of Public Welfare. If the decedent was over 55 and receiving medical assistance, then a notice must be given. And so what we typically do is when Tammy and I actually are going to the courthouse to probate, we typically have, let me go back to this last slide. We typically have the advertisements ready to go. We have the petition ready to go. And then typically we have the letter to DHS that we're going to send ready to go so that we can review that with the person who's being appointed as the personal representative. And then I can sign as the attorney who's handling the estate, and we can actually get those notices and those advertisements going as quickly as we can to help the administration process. Then typically you're going to do an inventory and appraisal, and that would be if there's real estate, personal property owned by the decedent at the time of death. And so we would want to, for example, if we have somebody who has a lot of personal property and either they may have had specific bequests or even if it went to the residue and we need to figure out about how much is that valued, usually we'll then look at, maybe an auction house coming in and providing a value so that we can make sure that we're paying the appropriate tax and valuing those assets properly. We want to make sure that we're paying all debts and expenses. And the one thing I like to mention here, because I would say that this is a question that Tammy and I get asked most often with personal representative or executors, would be, is the personal representative ever liable for any of the debts or expenses of the estate? And the answer to that is, as long as the personal representative or the executor is handling things in the appropriate order. So for example, if the estate is insolvent, then Pennsylvania has a statute that actually gives the particular order in which debts must be paid. And if they aren't paid in that order, then that could potentially be problematic for that personal representative or that executor if they didn't properly pay things in the proper order. So that would be the only time that we really are concerned about the executor or the personal representative being held responsible. So I would say the second most often question is, when do the beneficiaries get their money from the estate? And so the answer to that would be that it kind of depends on the process. So the time frame can vary. It depends on what assets are in the estate. So we can do it really quickly, or it may take a couple of years. I would say that when Tammy and I are working on estates, our goal is to try to get everything wrapped up within a year. So there's normally a minimum amount of time that you have to let pass. And normally that's about 4 months that you want to make sure that you are waiting to do that. The 4 months have passed before you actually do any wrap-up documents. But anytime between 4 months and a year, I would say, is typical. And again, our goal is to try to get it done as efficiently as possible. I will say that I have worked at other law firms prior to starting my own firm in July. And I would say that estate administration is an area in which people do get frustrated about the timeline and how long it takes to do it. You can, as a law firm, do it very efficiently. And I do feel like we do have a good system here to get things done efficiently. But there are things that have to be done. So for example, if certain things need liquidated, then typically what happens is they get liquidated and put in an estate account. And then we have to send out releases and propose distribution amounts to all of the beneficiaries, and they have to sign off and agree to that. So again, even though it seems like it's pretty straightforward, sometimes it takes a while to get all of those things out to all the beneficiaries and then have them sign a return. I would say this spring we ran into some issues because normally we like to have them notarized, and some of the beneficiaries weren't able to get things notarized. And so that may have taken a little bit longer. Another thing that we have noticed is that if there's a charity and the charity is receiving a certain amount, above a certain amount, the Pennsylvania Attorney General's office gets involved. And sometimes that can make the administration process a little bit longer. And that could be because, for example, with COVID happening, Pennsylvania was shut down for a while. So we actually had sent a proposed distribution to the Pennsylvania Attorney General back in March, and we haven't heard anything yet. Even though normally we would hear more efficiently, we haven't heard anything since March. And I think that's just a result of Pennsylvania being shut down. So typically we try to wrap everything up. The estate gets wrapped up without having to get an order by the court, because if all the beneficiaries can agree to the distribution, then we can actually make a distribution without actually having to file a formal accounting with a court. And so again, we're talking about time frame. It's all about making sure we send the releases or the proposed order of distribution. They're kind of in the same thing there. Beneficiaries sign off agreeing to it. And then what that allows us to do is to make a distribution without having to do a formal court accounting. Now, one thing I will say is that sometimes you want to do a formal court accounting. So, for example, if someone like the Attorney General or DHS, the Department of Human Services, doesn't get back regarding a claim, sometimes you want to do an accounting because an accounting kind of cuts off their right to come forward against the estate. So that may lengthen the time frame of the administration process. And if it's not court ordered, the estate can be settled informally. And we talked a little bit about that. The other thing I will say that I do think is on later slides is you can make a partial distribution. So for example, if you have an estate that's worth $500,000 and you kind of know what the debts are coming in and you want to make a partial distribution of, say half of the estate out to the beneficiaries and then leave the remaining half to continue to pay bills for the administration process, you can do that. You just send out a partial release and say, hey, we're going to make a proposed distribution of this amount. And again, you have the beneficiary sign off on that. And if everybody signs off, you can make a partial distribution. So that's the other thing I like to make sure to tell clients is that you don't have to wait all the way to the end before money can be distributed. So when should you probate? So generally, these days going to be probated when there are probate assets. So I think it's easier to say what are non-probate assets. So non-probate assets would be anything that has a beneficiary designation on it or that's a jointly owned account. So for example, if my parents have a bank account that's jointly owned, when my dad dies, that doesn't have to be probated because it automatically goes to my mom. If my dad has a retirement account and has my mom designated as the beneficiary, that automatically goes to my mom. It doesn't have to go through probate. So probate is property that is owned solely by the decedent or by the decedent and someone else that there's not a right of survivorship. So let's say that my dad owned property with a sibling, his brother, for example, and it was owned as tenants in common instead of as joint tenants with right of survivorship. If it was joint tenants with right of survivorship, then by law, when my dad dies, it goes to his brother automatically without probate. But if it's owned as tenants in common, then it does go through my dad's estate. I always want to make sure that people know that the default in Pennsylvania is if you have a deed, it's owned as tenants in common unless it's between spouses or unless the deed specifically says that you're owning it with a right of survivorship. So I would say 90% of the deeds, especially if we're not dealing with husband and wife, are going to require the probate process in order to get that decedent's ownership interest to the beneficiaries or to that other owner. The other thing to remember is that if an account is less than $10,000, there is a Pennsylvania statute that says if you have a receipt of a paid funeral bill, then that account can be closed out to a spouse, a child, a parent, or a sibling without having to probate. So again, Tammy and I just did one where we had a bank account that was less than $10,000 and we didn't have to probate for that because that was the only asset that the individual had. Everything else was jointly owned or had a beneficiary designation, so we didn't need to probate just for that bank account with less than $10,000. So that's the other thing to remember is that if you do have an account and it's less than 10,000, then you can know that your executor or personal representative isn't going to have to open up a probate estate just to administer that account. Now, jointly owned property here, I mentioned this. So again, if it's jointly owned with someone and there's a right of survivorship, then it doesn't go through the probate process. So for example, we had an account where we actually had a child on the bank account with the parent. And in that case, there was no probate. Now, what's important to remember is that if it's multiple children, so in my family, like I have said before, I have 3 sisters. So if I'm on the bank account with my mom and my mom passes away, then legally that account automatically comes to me without going through probate. But the downside is if my mom was thinking, well, Sam's going to share that with her sisters, I'm under no obligation to do that because I was the joint owner. So I always like to talk to clients about that because sometimes they will have children on the account for ease. They'll say, well, it's easier because then they can pay bills for me if I'm unable to do that. And I always caution clients about that because they can do that using just a power of attorney document. It's the same effect. A child can write checks out of that. But when my mom dies, it doesn't automatically become my asset. If I'm a joint owner, it automatically does become my asset. So I always like to make sure that people know that there are some positives and some negatives to that. So with that being said, let's offer some caution about that. So what do we need to know when trying to avoid probate? Because again, the whole thing is we're supposed to talk about tricks to allow us to avoid it, but we also want to make sure that we're not creating other issues. So adding a joint owner is not always the best solution. And the reason is because it's subject to that joint owner's creditors. It could be eligible or included in an equitable distribution when a joint owner goes through a divorce. The joint owner of the bank account does have complete access to the account. And if something happens to that joint owner and they pass away, when it's going back to the parent, then you owe tax on that share of the asset. And then if it's real estate and you have a joint owner, then you do lose the ability to sell the real estate without permission of the joint owner or the joint owner's spouse. Now, let me actually give an example because it's easy for me to sit here and rattle off all of these things, but let me kind of give you a real life example. So again, let's take my parents. Let's say that they add me to their bank account and then I would get married and get divorced. What that means is that that account that wasn't my money to begin with, that my parents just added me on, is now subject to my divorce. So it could be involved in equitable distribution between my spouse and I. If I want to pull out all of the money because I'm a joint owner, I can do that. If I die before my parents, they're going to pay 4.5% tax on 1/3 of the value of that account because that's considered my 1/3 if I'm added as a joint owner. And then if it's real estate, what that means is if my parents wanted to sell the property, they would have to get me to sign off on the deed as well as any potential spouse I would have because my spouse would have a marital interest in that real estate. So again, you can add a child on, but the downside is that it's subject to their creditors. It could be subject to inheritance tax. And then I do have some say and control over that asset if I'm one of the joint owners. So again, just know that you can do it, but it might not be the best idea to do it. Now, the next thing is that if you're trying to avoid probate by having a life estate, so sometimes we'll have clients who say, well, I will just have a life estate in the property and I'll go ahead and convey it to that next generation. The downside of doing that is in Pennsylvania, we have what's called an implied life estate. An implied life estate means that if mom and dad transfer the property to me and retain a life estate in that property, usually people would say, okay, well, if it's owned by Sam now, she's not going to have to pay inheritance tax when mom and dad pass away. But Pennsylvania does have this concept of an implied life estate, which means that if mom and dad live there, then it's included in their estate for Pennsylvania inheritance tax purposes. So even though they only retained a life estate and they gifted the property to me, it's still going to be subject to Pennsylvania inheritance tax. It's also important to know that if you have a life estate, you do lose the ability to sell the real estate without the permission of, in this example, me as the remainderman. and my spouse if I would be married. And then also it doesn't pass according to mom and dad's will. So again, if they're saying that their estate is divided among my sisters and I 4 ways because there are 4 of us, but yet they conveyed the property to me and retained a life estate, when they die, that property automatically comes to me. So it's not going to be divided the 4 ways like they had wanted in their will. So it's just another thing to remember when you're talking about a life estate or adding somebody as a joint owner. So again, it can be a trick to avoid probate, but do you really want all of those negative implications from having a joint owner or for having a life estate? So what are some other ways that maybe you can avoid probate without having a joint owner? One is to have beneficiary designations on the assets and to keep them updated. Now, I always like to mention this because there is some discrepancy between, I don't want to say discrepancy, there's some discussion, I would say, between attorneys and financial advisors about beneficiary designations. So, for example, I was talking to a financial advisor recently within the last month, and he was saying, he always recommends that his clients have beneficiary designations on their accounts, but he's noticed that attorneys don't like that. And so I wanted to just talk a few minutes about that and explain kind of where everybody's coming from and then what our office recommends. So the benefit of having a beneficiary on an account is that it does not have to be probated in order to transfer that account. It is a trick to avoid probate. So that's a positive. The downside is that if you are not doing a comprehensive estate plan that includes beneficiary designations as well as a will, sometimes there can be an issue because one example that Tammy and I are working on is we have 4 beneficiaries designated on most of the accounts. So it was retirement, there was some life insurance, there was an annuity, I believe, and an investment account that had a transfer on death designation. And the decedent had designated 4 beneficiaries. They weren't children, they were nieces and nephews. But then in the will, she had her property going through the will, and the property, the real estate, was just going to 2 of the beneficiaries. So all 4 nieces and nephews were on designated beneficiaries of accounts, but only 2 of them were receiving the real estate. And the issue became, because there wasn't coordination between the beneficiary designation and the will, all of the funds, except for the house, passed by beneficiary designation. So those 2 individuals that received the real estate had no money to pay the taxes, expenses, and upkeep, which was a problem. So here at our office, I actually do recommend beneficiary designations. I always think that's really important. I think it's important for 2 reasons. The first is that it does avoid probate, and the second is that it does avoid a Medicaid recovery lien, which we'll talk about a little bit later. But a Medicaid recovery lien would be if somebody dies while they're in a facility and they're receiving Medicaid, the DHS can come back on the value that Medicaid had paid into the facility, can recover that against the estate, and they can only recover that against the probate estate. So if you have accounts that you could have a beneficiary designation, and either you don't or the designation is your estate. So for example, for my dad, it would be the estate of Dennis Wolfe. If he has that and he dies while in a facility, then DHS, Department of Human Services, can come back on the estate for whatever Medicaid had covered while he was in the facility. And so I think it's important to make sure that you always have a beneficiary designated to avoid the Medicaid recovery lien on there. But I do think that sometimes financial advisors and attorneys need to do a better job of communicating the comprehensive estate plan, because if you do have assets that are passing via the will, that there are going to be expenses that are incurred, then you don't want to have all of the funds passing to designated beneficiaries and then have the will say it goes to this particular individual and there aren't funds there to pay taxes and expenses. The other thing too is that if you are going to have an attorney help with the administration, the other thing you have to recognize is typically the attorney would get paid out of the probate estate or anything that's passing via will. If you have a beneficiary designation, they're not necessarily paid that way. So you would have to get all of the beneficiaries to contribute assets into the estate if you wanted to pay the attorney out of the estate. And so that's the other thing I like to make sure to tell people is that you just have to make sure they're coordinated. So again, here at our office, we do recommend the beneficiary designation to avoid probate as long as it's part of a comprehensive plan. So making sure that we're saying, okay, these are the assets that are passing by probate or through the will, and then these are the list of assets that are passing by beneficiary designation, and making sure that there's enough funds there to pay taxes and expenses. And the example that we have here is husband and wife name each other as the sole beneficiary of the IRAs. Husband dies first, and the wife never updates her beneficiary designation, and she didn't name a contingent beneficiary, and then she dies. Wife's IRA is going to pay to the estate as there is no named living beneficiary. So I always recommend that we have beneficiary designations, and not only do we have a primary, but we should have a contingent beneficiary listed as well in case that primary beneficiary doesn't survive. So that's one trick to avoid the probate process. And then making sure all marital assets are titled jointly. So in the early 2000s, the reason why a lot of married couples had individual assets was because the federal exemption was so much lower, and we didn't have what's called portability. So today, if my dad dies, he has a federal exemption amount of over 11 million. And if he doesn't use that amount, my mom can tack his unused amount to hers. But it used to be you couldn't do that. That actually came into play in about 2013. So prior to that, you couldn't attach a deceased spouse's exemption amount to your own. So if somebody died and didn't use it, they lost that exemption completely. And so a lot of times attorneys or financial advisors advise that marital assets be titled individually, some in husband's name, some in wife's name, to avoid that issue. Well, now we don't have that problem. So our recommendation is for married couples to actually have everything titled jointly. Now, I know that there are going to be some blended families where you might not want to do that. You might want to make sure that the assets are kept individually because there might be children of one spouse, with a second marriage. But I would say most of the time, you're going to actually want the marital assets to be titled jointly. That just means then when the first spouse dies, there won't be any probate that has to happen. And so it just means easier administration if it's jointly titled. Okay, so I liked this little cartoon. It says, when you've been married a long time, you get to know what the other person thinks, and wife's thinking that, and then husband says, no, you don't, in his thought bubble. And so I liked that. And so I thought it would be a nice way to break up all of this fun legal stuff. Okay, so here's another tip that I would say is to make sure you know what you own. And if you're meeting with an attorney and they're not asking about what assets you own, then that could be problematic because, you want to make sure that your probate estate and your non-probate estate are actually being distributed the way you want. So if you have only non-probate assets with a beneficiary designation or a joint owner, you could have this will that never actually gets used because none of the assets actually are getting distributed via will. So I would always, always recommend that even if it's an informal list of assets that you have that and you provide that to your legal counsel. In our office, we typically do a worksheet that actually says, list all your real estate, list all your bank accounts, and asks you to also indicate how it's titled, just so we have an idea of what type of probate estate are we talking about. It's also helpful because if something happens, then we do have a list that we can provide your personal representative so they know where your assets are held and who they need to contact. The other thing that's really important is the Pennsylvania unclaimed property. So when we're administering a estate, we always do look on the website for Pennsylvania unclaimed property just to make sure that we're claiming anything. If someone just passed away, we'll search their name because you can do that, and then it'll come up if there's any unclaimed property. You want to make sure that you're claiming that. And usually it'll say if it's over 100 or under 100. And so again, you want to make sure that your legal professional is doing an unclaimed property search as part of the estate administration. And then the most commonly unknown probate asset is stock, because if it's not held in a brokerage account or it's not held as part of your retirement account with a beneficiary designation, if you just hold the stock, either as stock certificates or even as book entries, that is considered a probate asset unless there's a transfer on death or a joint owner. And then one tip there is meeting with an estate and elder law attorney to establish that estate plan. And again, they need to know those assets in order to be able to give you the best comprehensive plan. So why would you establish a trust? And I will tell you, I'm just going to talk about this briefly because we're going to do a whole seminar talking about the different types of trust and the taxation of it. So I don't want to spend a lot of time because this could actually be multiple seminars just talking about trusts. And I really enjoy trust, so I can get pretty long-winded, but I'm going to try to keep it really simple. So there are two types of trusts. There's a revocable trust and there's an irrevocable trust. Sometimes I will hear people say, well, is it a living trust or not? And living trust just means that it's created during your life as opposed to through your will. So you can have a living irrevocable trust, or you can have a living revocable trust. Again, that's just talking about when did you create it? Was it during your life? Is it intra vivos while you're living, or was it created when you died through your will? That would be a testamentary trust. We can also do a special needs trust, and then depending on what you're trying to accomplish, we can make it grantor or non-grantor, and that would be talking about the taxation of it and how it's going to be taxed for income tax purposes. So it can be a grantor or a non-grantor trust depending on what we're trying to accomplish. If you set up a trust and you fund it while you're living, it avoids probate. So if you just set up a trust and your will says when I die, everything pays into the trust, you're still subject to probate. It's only if the assets are actually titled in the name of the trust that you're actually going to avoid probate. And we have education trusts, charitable trusts. We have trusts to qualify people for veterans benefits, and then we have children's trusts as well. So there's also sometimes a misconception about what happens if there's a trust involved. So I would say the difference between probate and administering a trust, there's really not a huge difference because the trust administration is a lot like the probate process. So they're very similar, a lot of the same procedural requirements. So it still requires notices, advertisements, certain tax returns to be filed. So I'm explaining all of this because there was a few years ago, Pennsylvania Attorney General's office did file a lawsuit about living trust sales schemes. And so it was where usually an attorney would have like a seminar and have clients there and they would sign up for these living trusts, claiming that it would avoid probate and that it would cut down on the administration when you died. And the problem is that the attorneys weren't taking the time to fund the trust. So you were still subject to probate. And again, probate doesn't really cost all of that much, and you still have to administer the estate. So it's very similar process. So when someone passed away, it wasn't really doing what all of the claims were, which was cutting down on expenses or eliminating probate. And so Pennsylvania Attorney General did take a really hard stance against that living trust sales scheme. So I always say, I have the link there that you can go to research it. So I always say you're not going to do a trust solely to avoid probate. There may be other reasons that you set up a trust, but you're not going to set up a trust solely to avoid the probate process. A trust does provide, though, other things. So sometimes it can provide creditor protection or long-term care planning. So like planning, protecting assets against nursing home. It could be that you're doing federal estate tax planning or federal gift tax planning. It could be that you're protecting your future generations. So again, maybe your child is married to someone you don't like and you're concerned about a divorce, or it could be just as simple as if something happens to your child, you want that share to go on to your grandchildren. So sometimes you'll use trusts to protect your beneficiaries, and you can do that using a trust. So probate positives. So again, the whole goal of the seminar is to talk about what are some benefits, what are some downsides, what are some tricks to avoid it, and what happens if you do avoid it. So one thing that I wanted to make sure is to highlight the positives of probate. So assets are not frozen as a part of the probate process, and it is a common misconception that no distributions can be made until the estate is complete. You can make partial distributions, and I think I had mentioned that earlier. So you can make partial distributions of the income or of the principal throughout the estate administration process as long as you have those beneficiaries agree to that. And so again, if you have an estate that you are the executor of or that you're a beneficiary of and it's taking a really long time, you don't think it should be, it's worth asking if the attorney hasn't already brought it up about a partial distribution. So always ask if that's possible because the answer is yes, you can do a partial distribution. The cost of probate in Pennsylvania isn't outrageous. So a probate fee is typically between $100 and $400 and it's going to be based on the value of the probate assets, number of pages in the will. the number of short certificates that you need. And that's sometimes a question we get asked, how many death certificates or how many short certificates do you need? And typically when Tammy and I are trying to determine that, we look at the financial institutions. So if you have 5 different financial institutions, so you have a bank, you have an insurance company, you have a retirement company, and then let's just say you have 2 brokerage accounts. So maybe like an Edward Jones or a Merrill Lynch or a Raymond James, you have accounts there. You're going to need a short certificate and a death certificate per institution is typically what we would recommend. The other time that you might need more is if you're transferring title of a vehicle. Sometimes you're going to need a short certificate for that as well. So we'll often get asked that question. And now I certainly understand because the cost of death certificates and short certificates have increased. Death certificates used to be only like $6 per death certificate, and now they're about $20. And you can get them much easier through the funeral home than you can once that time lapses and you actually have to go through the state. So sometimes we'll get questions saying, how many should we get? And as a rule of thumb, you're going to want to get 1 per financial institution. And again, that's why it's so important to have a list of assets, why your attorney would need that list to be able to then guide you about the number of shorts and the number of death certificates. And then advertisements typically cost $200 to $400. And again, you are going to actually advertise it in 2 different publications, a newspaper general circulation and then a legal journal. And so again, combined, that's usually going to be, close to 400 because it's, I would say, 200 per publication. So all in all, the cost of probate isn't that outrageous. And like I talked about, it doesn't take a whole lot of time. Now, normally what we'll do when Tammy and I are probating, when we used to do it in person, we would schedule like the morning and we would go up to the courthouse, we'd go ahead and probate. And then as soon as we're done probate, we would then go to like the bank and go ahead and close out that accounts with our client. The actual probate process doesn't take that long. And now that we are able to do it virtually, it takes even less time. I would say more time is our office getting the petition ready and making sure all the documentation is ready. And then formal accountings can be, between 100 and 300 or more if they're needed, but they aren't always necessary. Most of the time we're able to close out an estate informally without an accounting. Minimum invasion of privacy. So when you probate, the information does become public record. However, even with non-probate assets, the information does become public record because you're filing an inheritance tax return. So I hear a lot of times people say, well, I don't want to go through probate because I want to keep things private. If somebody really wants to know, they can go up and just look and get a copy of the inheritance tax return. So just by avoiding probate, you aren't going to avoid the fact that information can be found. So I always like to make sure to mention that as well. So ways that we want to make sure to protect identity theft, because that's when it happens a lot of times. So our office does send a notice to the 3 credit reporting agencies when someone passes away and the Pennsylvania DMV, noting that this person and this social security number connected with this individual, that the person has died and no new credit should be issued and that all of the accounts should be closed that are under that social. We always offer to shred any sensitive documentation, and then we're always happy to actually request a credit report if that would be helpful after we've closed out those credit accounts. So your final wishes, how do you make sure to do that? So you make sure you have a plan, you have to know what you own, and you have to know which assets have a beneficiary designation and who that beneficiary is that's on the account. And the types of ownership. So we talked about tenancy in common. So it's owned by 2 people, but there's no right of survivorship. We have joint tenants with right of survivorship, and then we have tenants by the entirety. If you have a copy of the deed, if it's silent, but it's between husband and wife, the default is tenants by the entirety, which means that when one spouse dies, it automatically goes to the other spouse. Otherwise, unless it specifically says joint tenants with a right of survivorship, then you're dealing with tenants in common. And when one person dies, that person's share goes through probate. Okay, here's another example. So we have a decedent, and in his will, he left $1,000 to his church, $2,000 to each of his grandchildren, and the remainder goes to his children equally. However, during his life, he titled his real estate jointly with his 3 children, and he put transfer on death provisions for all of his accounts. So they passed directly to his children. So what that means is he took all of the time to meet with the attorney and have the $1,000 going to his church and $2,000 going to his grandchildren, That's not going to happen because there are no funds that are actually passing through the will in order to satisfy this bequest, because he has a joint owner on his real estate and then he has transferable death on all of his accounts. So you want to make sure that, again, it's a comprehensive estate plan, that you're covering things that are passing probate through the will and then non-probate assets. Now, one thing I will tell you is that sometimes we look at the charities, and we're going to get to this in a couple of slides, and we look at retirement as a possible way to make sure to fulfill those charitable bequests. And I'm going to talk a little bit about why that's helpful. So it's not that you can't get money to charities. It's just in this case, you had all the money being diverted away from the will, so there was nothing to satisfy it. So when the decedent passes away, the $1,000 bequest to the church and the $2,000 bequest to the grandchildren will not be made because there weren't enough funds in the estate to satisfy those bequests. So are you including a charity? And I just worked on this with a client just this week. So what they said to me is they said, I want to make sure that 10% of the value of my estate goes to charity. So based on their estate, that would be $100,000 to charity. So if, when we're trying to figure this out, because retirement is actually taxed or subject to two taxes, meaning that when you die, it's subject to Pennsylvania inheritance tax. And then as the individual draws out of your retirement, your beneficiary draws it out, then it's subject to income tax. So sometimes we'll say, okay, well, it would be a great idea if the charity is the beneficiary of some retirement. So if you want $100,000 or 10% of your estate to go to charity, but knowing that your retirement is $400,000, then we'd actually designate the charity as a 25% beneficiary of their retirement. And we would do that because even though it's 25% of the retirement, that's 10% of the entire estate. And then what we like to do is we like to coordinate with a financial advisor and every year revisit that, because your retirement is going to go up and down. So, we may need to adjust that percentage either up or down depending on what your retirement funds are doing. But then you don't have to change your will anytime, you would decide to change the percentage to charity. It would just be a beneficiary change that would be done with your financial advisor. So what we would do is in this case, if it's husband and wife and they want everything to go to spouse, the primary beneficiary would be the spouse. And then the contingent beneficiary would be 25% to the charity. And then it shouldn't be 80%. It would be 75% to the children per stirpies. So again, that would make sure that the $100,000 gets to the charity, which would be 10% of the gross estate. And then, like I said, every year or two, you're just revisiting the amounts in your retirement and updating that percentage as your asset value goes up or down. Now, let's talk about some death taxes. So the three-headed monster, what type of taxes are we talking about? So we're talking about Pennsylvania inheritance tax, federal estate tax, and then income tax, both at the Pennsylvania level and at the federal level. Now, what I can tell you is this used to be a much scarier situation with the federal estate tax than it is now. Now it's not as big of a deal, and we'll get to this on the later slide because the exemption is so high. So we have a businessman on his deathbed. He called his friend and said, Bill, I want you to promise me that when I die, you'll have my remains cremated. And what, his friend asked, do you want me to do with your ashes? And the businessman says, just put them in an envelope and mail them to the IRS and include a note that says, now you have everything. So I wanted to include that again, just to kind of break it up. So fun joke that you can tell at the dinner table tonight. So how do we shed some light on these taxes and account for that? So we have the Pennsylvania inheritance tax. That is a tax that is imposed on the privilege to receive assets when someone passes away. So if you transfer them during your life and you survive it by 1 year, it's not subject to Pennsylvania inheritance tax. But if it's getting to your beneficiaries as a result of your death, they're going to pay Pennsylvania inheritance tax. Pennsylvania was the first state to impose an inheritance tax, and it first imposed the tax in 1826. The states that do also impose an inheritance tax are Indiana, Iowa, Kentucky, Maryland, Nebraska, New Jersey, Pennsylvania, and Tennessee. Some of those states, though, do have like an exemption, if you will. So if it's less than X amount, you don't have to pay tax. Pennsylvania is not that way. Pennsylvania is taxed on $1. So there's no exemption amount, meaning that if you have an estate of less than a certain amount, there's no inheritance tax. You're always going to pay inheritance tax unless it's retirement or it meets one of the other exemptions. So avoiding probate is not the same as avoiding Pennsylvania inheritance tax. So you can say, well, I don't have to probate. So for example, if a bank account is less than $10,000, you don't have to probate, but there may still be a Pennsylvania inheritance tax that's due. There may be a joint property. So my sister and I might own some property that when I die, it goes to her, but it's still going to be subject to inheritance tax. It's just not subject to probate, or it avoids probate. So whether the property is probate property has no bearing on whether or not it's subject to Pennsylvania inheritance tax. And the best example would be retirement. So often I meet with husband and wife who say, well, I have a retirement, but I went ahead and named my spouse on it. So we don't have to worry about probate, nor do we have to worry about Pennsylvania inheritance tax. And the answer to that is you're right. There's no tax on it. However, it's reportable on the inheritance tax return, meaning a Pennsylvania inheritance tax return has to be filed showing the date of death value, and then it all went to the spouse. It's not taxable, it just has to be reported. So this is a chart of the tax rate. So there are certain things that are exempt. So exempt are charitable organizations and government entities. And then a spouse, it's 0%. So it's not that they're saying that it's exempt. What they're saying is right now the tax rate or the spousal rate is 2%. Grandparents or anyone that's down your line, children, grandchildren, and stepchildren are going to be referred to as lineal descendants, which means 4.5%. A sibling is 12%, and then anyone else is 15%. And that would be 15% on the date of death value. So what's property that's subject to inheritance tax? Pretty much everything. Personal property is going to be subject to it. Jewelry, apparel, household goods, all of that is still going to be subject to inheritance tax. Annuities are. Individual retirement accounts are also going to be subject to it. Any gifts that are made within a year without adequate consideration. So if my dad gives me $10,000 and it's not because I'm providing care for him, then he dies within a year, then that is going to be subject to inheritance tax. I do get a $3,000 kind of exemption. So any gift that's over $3,000 that was made within 1 year is going to be subject to tax. And then any trust, if there are certain powers that the person who created, the grantor, retained, then it's still going to be subject to inheritance tax. Now, I do want you to know that Pennsylvania, I believe in 2012 and 13, they did offer some exemptions for certain categories. So, for example, death benefit proceeds of life insurance are exempt from inheritance tax. Also, family farms are exempt, and that was, I think, around 2012, and then family businesses are also exempt around 2012, 2013. There are some requirements in there. So for a family farm, it has to go to a qualified transferee. So that would be a child, a grandchild. They have to farm it for at least 7 years after death, and it has to earn $2,000 worth of gross income every year, and you have to do an annual certification. And there are 2 exemptions related to family farms. One of them is just on the real estate for farming, and the other is actually on buildings and the real estate. And then family businesses are also exempt if they have a net book value of less than $5 million. They've been in existence for 5 years prior to death, and they're going to continue for 7 years after. And you have less than, I think it's 25 employees, then there's no inheritance tax. So there are 3 big exemptions now that you want to make sure that whoever your attorney is when you're meeting with them, that they know that, okay, or at least mention that. Then we have another little cartoon that says, don't worry about it. The inheritance tax doesn't apply to kings. Unfortunately, in Pennsylvania, it still would. So property owned by husband and wife with right of survivorship, that we don't have to worry about the tax unless, so what this is saying is that a tax return doesn't need to be filed unless the decedent's spouse was added within 1 year of death. So any jointly owned asset with a spouse doesn't need to be on the Pennsylvania inheritance tax return. However, if they were added on within a year of death, then they do. And again, their tax is 0%. So life insurance, death benefit proceeds, transfers to government entities, transfers to charitable organizations, anything from the Social Security Administration or the VA, lump sum burial benefit from the U.S. Railroad Retirement Board, they're also all exempt as well. So when you're worried about Pennsylvania inheritance tax, you do have to value the property, and the inheritance tax is based on the date of death value of the assets. So if it's a financial institution, we just send a letter saying, what's the date of death value for this account, so that we know. And then that property is subject to inheritance tax, and it's going to be taxed on whatever the market value is. For real estate, Pennsylvania has two options. You can either get it appraised, and it can be the percentage. So for example, if it's coming to me as a child, it's 4.5 or whatever the appraised value is. The other way you can do it is you can take the tax assessed value and multiply it by the county's common level ratio factor, which in Franklin County is 9.09, and then you would pay inheritance tax of 4.5% on that value if you're a child. Who pays the taxes? It's in the will, there could be a provision that says that the will is going to take care of paying all the inheritance tax. But if it's not provided in there, then it's paid through property passing through the will from the residue as a general administration expense. However, inheritance tax on property passing outside of the will is paid by the person who's receiving it, so the beneficiary, for example. And again, that's why it's so important to coordinate, because you want to make sure that you're getting the best plan tax-wise. Like, do you want it to be paid from the will? Do you want it to come out of the beneficiary designated account, or do you want it to be paid through the will? So again, all of that is really important to make sure that you are thinking through, and you want to make sure it coordinates. So who must file the Pennsylvania inheritance tax? The executor or the administrator of the decedent's estate, or the transferee of the decedent's property must file Pennsylvania inheritance tax return. So for example, if you don't have to probate, because maybe it's all designated beneficiaries or joint property, the person who receives the asset is responsible for filing the inheritance tax return if there is no executor appointed. When must you file it? The return has to be filed within 9 months of the date of the decedent's death. However, if you pay the inheritance tax within 3 months of the date of death, then there is a 5% discount on the tax that is owed. So that's really important. So in our office, we put all kinds of ticklers on our calendar, all kinds of reminders, because we want to make sure that we are paying the tax within the 3 months so we get the 5% discount. That can really matter if it's a 15% designated beneficiary. So if it would be my niece or nephew, then it would be really important to get that discount. I also like to mention that the Pennsylvania Bar does state that accountants have to be really careful about preparing Pennsylvania inheritance tax returns, because it is the unauthorized practice of law. So I just wanted to mention that, just in case that is something that you're thinking, oh, I'll have my accountant do it. You also want to make sure that you do have the attorney look over that, just to make sure that everything is in compliance. So the federal estate tax, the reason why we're not so worried about this one is because the exemption is so large. It's $11,580,000. Anything over that is at 40%. Most people that we meet with, we don't have to worry about that. It'll be interesting to see when the election happens if that changes. Depending on who gets elected, they may lower the exemption, and so we may have to worry about that again. If you have a federal estate, you do have to file a Form 706 or federal estate tax return. That's due within 9 months. Okay, so the other thing is that we have to file income tax returns. So a final personal income tax return, or a PA 40 and a Form 1040 has to be filed, as well as an estate income tax return, or a 1041 or a PA 41. And this is important to know. The stepped up basis, the reason why I have this on here is a lot of times I get questions about, well, what happens to the basis of the property? So basis is what you have put into the property. So if I purchased a property for $100,000, that's my basis in the property. If when I die, if my beneficiaries, let's say it's my children, if they pay 4.5% tax on the value of the property, they get a stepped up basis on it, which means that whatever the fair market value is on that property on the day I die, that becomes their basis. So if they liquidate stock or real estate, then it's less income tax they have to pay. And the reason why this is so important is because we have to coordinate with the accountant and the attorney's office to make sure that the inheritance tax return is properly disclosing the date of death values, because that's then going to show the stepped up basis that you're going to have in those assets. And so again, that's really, really important to make sure that you're properly disclosing that. So again, if you have a beneficiaries at 4.5%, you may want them to pay that tax, because they get a stepped up basis, which means if they then liquidate it, it's less capital gains tax. So what should you do now? You want to make sure you have an estate plan in place. And the one thing I would say is a lot of husband and wives have I love you wills. So I'm leaving everything to my spouse is what it'll say. And then if my spouse doesn't survive, then to my kids. At our office, we recommend I love you but wills, which means that you say everything is going to my spouse unless they're in a nursing facility and receiving government benefits. And then I do want it to bypass the spouse. So we want to make sure that we have that bypass in there. And we want to make sure that you're keeping your estate plan updated. People change, the law changes, and so you may need to adapt your estate plan. We always recommend an annual review. You're going to want to keep your original will in a safe place because the presumption in Pennsylvania is that if a will is lost or destroyed, that person intended to revoke it. And so if you have to prove that that was not the case, that they didn't mean to revoke it, there can be litigation involved there. You want to make sure you're choosing your executor carefully. You pick 1 or 2 people that you might trust, and then you're going to name a successor as well. I'm going through these last slides quickly just so we can get through the material. So if anybody has questions, you can feel free to ask. Make sure your executor knows where you're keeping the will. Make sure you have an asset list that the executor can receive or access after your death, and have information available to your executor with information regarding your credit cards, any loans, and the attorney, for example, that handled your estate planning so they know who to contact. Explain your wishes as is with personal property. That is the most commonly fought over asset. So even though monetarily it might not actually have a lot of value, this is the personal property, the household goods, those things are what's fought over most often. If there's specific items that you want to be distributed, then you want to make sure you include that in your will. You want to make sure that if you want to, that you have prepaid and prearranged funeral plans. That's money specifically set aside. That way it's less stressful for family members. It also allows you to go ahead and choose the type of burial that you would want. If you have any minor beneficiaries, you want to make sure that you have the necessary provisions in your will that would allow either the executor to create a trust or to set up an UTMA account if they need to do that in order to hold those accounts. Keep your beneficiary designations updated. Have assets like your IRA or your annuity paying to the estate can cause larger income tax consequences and require the estate to be probated. So again, this is where our office does recommend beneficiary designations, as long as your beneficiary designations coordinate with your will. Okay, so I know that these were a lot of slides. I think Amy told me it was over 50, so I knew I was going to have to be moving really quick. So summary is that probate is not necessarily a bad thing. It doesn't cost a lot. It's not overly burdensome, but we can avoid it. We just have to be careful how we do that. So rule of thumb is you want to keep your estate plan as simple as you possibly can while still accomplishing your goals. You're able to do that by making sure your beneficiary designations and the way you own the property is consistent with your estate plan so that you can, when you die, things get where you want them to go. And you want to make sure that you're handling the death taxes. As long as you know what's coming, it's not as scary. So it's like turning on the lights and being able to plan that way. If you plan ahead, you can stay organized and save money. Okay, so that's our kicking the bucket gracefully. I know it was a lot of slides and I know we really pushed through that. I am happy to answer any questions anybody has. Our goal is to do monthly virtual seminars, and so we'll always send out an email to let you know when that is. If you have any topic suggestions or if you would like to recommend a different time, please let me know because we're open to doing it different times of the day. Amy is going to send out everybody a link that just allows you to fill out a survey so that we can have some feedback. So it allows you to kind of rate the presentation and offer some feedback about what you like, what you didn't like, or what you would like us to cover. Do I have any questions? If anybody has any questions, you can put them in the chat box and I'm happy to answer them. Does anybody have any questions? I'm not seeing any, but I'll just hang out just a minute longer just to make sure. I want to thank everybody for getting on the virtual seminar, and I do want to thank you for taking the time to fill out the survey. That is so helpful for us here at the office to be able to plan for the next seminar and to make sure that we're getting information out. So I do have a question. So one of the questions is, how often should you review your will? I recommend every year. So we actually have annual review appointments here at our office where we review with a financial advisor or with the accountant the estate plan and just go over, what are we looking at if you would die tomorrow? What are the taxes? Where would your assets go? How would the taxes be paid? Those type of things. We do that every year. We don't charge for the annual review. We just like to keep updated on what's happening in your life, tweak any asset list that we have, and make sure that you're up to date on the laws that might have changed or that might be new for you. So I would say every year you should review it along with your beneficiary designations. Do I have any other questions? Okay, over my shoulder on this side, I do have a copy of the book that I helped author. If anybody would like a copy, you're welcome to reach out to Amy. We can get you a copy of that. It's complimentary. If you have any questions about how to plan for the second half of life, we're happy to help do that. And we'll make sure to send information about the next seminar. And thank everyone. I thank you so much for getting on here. And we really appreciate you. So thank you so much. I'm going to go ahead and end the session and stop the recording. So thank you, everybody. Have a great